Good afternoon, everyone. I'd like to welcome everyone today to our event titled The Forgotten Constitution, the Role of States in the Development of American Constitutional Law. My name is Michael Froge, and I'm the president of the Federalist Society chapter here at Malware. We're excited to have you join us for this important conversation in celebration of Constitution Day. Before I begin, I just want to say, out of an abundance of caution and love of your neighbor, if you could just be mindful of where you're sitting. We do want to abide by IU's COVID policy, social distancing. So, especially if you're eating, that's really crucial. The Federalist Society is a group of conservatives and libertarians interested in the current state of legal order. It is founded on the principle that the state exists to preserve freedom. The separation of powers is central to our Constitution, and that it is the duty of the judiciary to say what the law is, not what it should be. The Society seeks to promote an awareness of these timeless principles and to further their application through lively debates and discussions like we have here today. It is my privilege this afternoon to introduce our distinguished panelists. My closest, we have Justice Jeffrey Slaughter, who was appointed to the Indiana Supreme Court by Governor Mike Pence in May 2016. He took the oath of office as Indiana's 109th Supreme Court Justice on June 13, 2016. He was retained by voters in 2018. Justice Slaughter was born in Gary, Indiana in 1962 and grew up in nearby Crown Point. After graduating from high school in 1981, he attended Indiana University here at Bloomington, where he was elected Phi Beta Kappa, and in 1985 received a Bachelor of Arts in Economics, graduating with high honors. In 1989, he received an MBA in Finance from the Kelley School of Business, and his Juris Doctorate cum laude from IU Law School. After law school, Justice Slaughter served as a law clerk to Chief Judge Alan Sharp, United States District Court of Northern District of Indiana and South Bend. He then worked in private practice with the Chicago office Kirkland & Ellis, concentrating on antitrust, bankruptcy, and other complex business litigation. From 1995 to 2001, he served as special counsel to the Attorney General of Indiana. Before joining the Indiana Supreme Court, Justice Slaughter was a partner at Taft in Indianapolis and litigated complex business disputes in both state and federal courts. Justice Slaughter has been an active member of the Seventh Circuit Bar Association, the Appellate Practice sections of the Indiana State Bar Association, and the Indianapolis Bar Association, and most importantly, the Federalist Society chapter, Lawyers chapter in Indianapolis. Committed to furthering civics and constitutional education, Justice Slaughter has volunteered as a judge for the We the People competition since 1996. Next to him, we have Mr. Thomas M. Fisher, who happens to be my boss and mentor. He has served as an Indiana Deputy Attorney General since February 2001 and was named Indiana's first Solicitor General in July 2005. In that role, he has handled high-profile litigation for the state, defends state statutes against constitutional attack, advises the Attorney General on a range of legal policy issues and questions, and manages the state's U.S. Supreme Court docket. A two-time recipient of the National Association of Attorney General's Best Brief Award for excellence in U.S. Supreme Court brief writing, Mr. Fisher has argued 4 times before the nation's highest court. His U.S. Supreme Court practice has also included authorship of dozens of cert stage and merit stage amicus briefs on a range of important issues, including jury impeachment, federal preemption, legislative prayer, public 10 commandment displays, the definition of marriage, abortion regulation, right to trial by jury, habeas corpus, and federal taxpayer standing. In addition, Mr. Fisher has argued dozens of high-profile cases, both before the Indiana Supreme Court and the Seventh Circuit Court of Appeals, including successful defenses of Indiana's Choice Scholarship Program, its popular telephone privacy laws, and its alcohol distribution regulations. Other cases have included constitutional defense, abortion regulations, parental rights laws, judicial speech canons, Medicaid statutes, the definition of marriage, state toll road leasing, and public school funding, among other important subjects. In 2018, Mr. Fisher was named a fellow of the American Academy of Appellate Lawyers. To our far left, we have Professor Ryan Scott, who joined the Malware School of Law in 2009. He teaches and writes on criminal law and procedure, federal courts and jurisdiction, and the separation of powers. Professor Scott's scholarship and research examines structural and procedural interactions between the judicial branch and other branches of government, particularly in the criminal context, He has written extensively on criminal sentencing in the area where legislatures and executive agencies have sought to restrain the wide discretion historically employed by judges. He's also studied efforts to influence judges indirectly through the judicial appointment process, strategies for encouraging judicial retirements, and the semi-retirement program of senior judges. After graduating from law school, Professor Scott worked for Judge Michael McConnell, U.S. Court of Appeals for the 10th Circuit. He then served as a Bristow Fellow in the Office of the U.S. Solicitor General. Before joining the faculty, he worked for 2 years as an associate in Supreme Court appellate practice at Melvin A. Myers in Washington, D.C., and he was appointed Associate Dean for Academic Affairs in 2019, Litigation Public Interest Law. So with that, I will pass it over to Professor Scott, who will be moderating our panel discussion. At about 12:55, we're going to pass it over to you guys. So as you're listening to this presentation, be thinking of interesting questions to ask our distinguished guests. So with that, can I have a round of applause for our distinguished.
Thank you so much. It's a pleasure to be here, pleasure to be serving on panel again, 6 feet and 12 feet to my right, respectively, with 2 of our distinguished alums and who have been friends to this chapter of the Federalist Society for many years. This is also the first in-person panel I've done in 2 years, which is really thrilling. So it's so good to see you again in person. Nice to be back. So our topic today is the role of states in the development of constitutional law. A lot of our attention when we talk about constitutional law focuses on the United States Constitution. That's understandable given its prominence in our system of government. But state constitutions both predate the US Constitution. Founding era state constitutions were an influence for the writing of, the drafting of the first US Constitution. And the relationship has been reciprocal. Subsequent state constitutions, including the Indiana Constitution, powerfully influenced by the content of the federal Constitution. And today, state actors of various kinds, both state litigators like state solicitors general and state judges, state court judges, influence the development of constitutional law both at the federal and state level in myriad ways. And that's the broad topic of our conversation for today. So I'm going to start by asking our panelists to talk about history and the role of states in the development of constitutional law over time. And I'll pitch this at a pretty high level. Feel free to talk either about founding era history or about the history in the course of your own careers, the role that you've seen state court judges and state litigants play in the development of constitutional law. I guess I'll start with Justice Slaughter just to tee it up for you first.
Pleasure to be with both of you gentlemen. Thanks to the Federalist Society for hosting this event, and thanks to all of you for being here this afternoon. Certainly among my generation of lawyers and judges, that is those of us who attended law school in the 1980s, I think we were hardwired with the idea that the most likely entity to violate individual rights were states, and where those who had been aggrieved by state violations would turn was to the federal courts, and that federal judges would vindicate federal rights, statutory sometimes, often federal constitutional rights, against their infringement by states or state actors. In many respects, that hardwired view was justified, but that's only part of the truth. The rest of the story, as Paul Harvey used to say, is that federal courts weren't always so protective of individual rights. And indeed, states, and I'll talk, given this audience and the court on which I sit, there are ample antecedents in state constitutional law that also provide ample protection for individual rights. And just one brief story, if you're not aware of it already. Some of you may recall that Indiana is the 19th state admitted to the Union in 1816. And our very first constitution that was adopted in connection with statehood, 50 years before the 13th Amendment was ratified as part of the US Constitution in 1865, which of course prohibited both slavery and involuntary servitude. Our own 1816 Constitution in Indiana had a similar prohibition against slavery and involuntary servitude. And if you're not familiar with the case of Polly Strong, decided by the court on which I sit in 1820, you should be. Polly Strong was born into slavery in what was Virginia. Slavery was common. She was relocated to what became the Northwest Territory, that part of the old pre-United States that formed this northwest of the Ohio River. Today, it's mostly the states of Ohio, Indiana, Michigan, Illinois, and Wisconsin. But in the Northwest Ordinance that established those territories, slavery could not flourish, wasn't lawful there, but those who were transmitted from slavery in one state could not be liberated in another. So the question became before our court, was somebody like Polly Strong, who was lawfully a slave in the Northwest Territory, what was her status in the newly admitted state of Indiana, which had a constitutional provision prohibiting such things? And our court, to its credit, found that whatever may have been the law of the United States, the law of the Northwest Ordinance, the law of Indiana, and its constitutional provision must prevail. And Polly Strong was granted a writ of habeas corpus, and she was then a free person in the state of Indiana as of 1820. I'll turn over the baton to General Fisher here shortly, but of course, at the same time that Polly Strong was getting rights vindicated under our state constitution, there are any number of stories in early and not so early U.S. history in which the federal courts did not recognize individual rights that we've come now to appreciate. Of course, the infamous Dred Scott decision in 1857, Plessy versus Ferguson in 1896, Buck versus Bell, the forced sterilization case in 1927, the Korematsu case in 1943 or 4, the Japanese internment decision, Supreme Court decisions in which we today look back on those decisions as being clearly wrongly decided, that those were federal courts rejecting individual claims under the federal constitution. The theme of which is, that I hope you'll take away from this if nothing else, is that state courts were and state courts remain a source of independent vindication of constitutional rights under our own state constitutions, if that may provide greater rights than the federal constitution provides.
Great, Jeff. Thanks for that kind of summary of Indiana's role in early role, at least, in trying to rid the nation of slavery. And indeed, I think the part of what's interesting about that story is that the source, as Justice Slaughter indicates, of the Indiana constitutional provision being the Northwest Ordinance. Congress had laid the groundwork for many of the arguments that then became the focus of debate in the middle of the 19th century leading up to the Civil War over whether Congress could in fact outlaw slavery in the territories. And so it was kind of that seed that got planted that eventually became part of the Indiana Constitution that became a very important foothold in that debate. One of my favorite quotes from the founding era about state constitutions, and don't we have all several from which we would like to choose in that regard? One of my favorites is from Thomas Paine, who referred to state constitutional law, state constitutionalism, and the efforts of states to pull together their constitutions as the coronation of the rule of law. Now, of course, he was playing on his hatred of King George and the crown generally, but he was pointing to something very important that has kind of stuck with me for a long time, which is that this was an important moment in history when many ideas that had taken hold in England and had generated, in some semblance of what we think of today as the Anglo-American rule of law, really began to crystallize in that founding era. And Paine and even John Adams both were looking in very, very different ways to states and colonies as independent sources of government structure and of rights, to kind of provide that intellectual heft to formally step away and justify stepping away from Great Britain. So all of that, I think, is critical to keep in mind as we examine states and their role in the development of the rule of law more generally. Now, I want to take one moment for a shameless plug. If you're interested in this subject, if you are inspired by what you hear today, and again, who wouldn't be? I actually teach a course in the spring on state constitutional law, and we examine this subject in some depth, both in terms of historical significance and more recent developments in constitutional law at the state level. And it's both Indiana and certainly a focus on Indiana, but it's also national in scope. We compare constitutions over time and over geography. And we get to really sink our teeth into these issues. And one of the things that really continues to draw my attention is how we think about the development of the rule of law within state constitutions and their role. Now, Mr. Froge, when he was talking about the Federalist Society, he spoke in terms of being a society that wants to examine the nature of the rule of law and of having the view that the state exists to preserve freedom. And this is a concept that I think all of us can think about and sometimes struggle with. Sometimes we think of the state as being opposed to freedom. Certainly, if we go back to Justice Slaughter's experiences in law school and in my own to some extent, the idea that however one defines the state, that it is actually meant to be, thought of as something that's antagonistic to freedom. But indeed, that's not the way that the philosophical construct that gives rise to our society, is based. Well, as I struggle with that idea and with, as I think about the relationship between the state and freedom, and as I was doing that in law school, I had the opportunity to take an Indiana constitutional law class that did kind of inspire me towards thinking about these ideas. And one of the places that really crystallized the relationship between the state and freedom was an Indiana Supreme Court case about the Indiana Constitution, a case called Price versus State. And it was a really wonderful disquisition on why we have a state, and it was about the nature of police power and where the limits of the police power, that is the power to regulate for health, safety, welfare, and morals of the public, where that starts and where that ends, and how it exists in an effort to promote the flourishing of individual liberty. And I think as much as we get caught up in talking about the US Constitution and all of the important issues that surround modern cases and even older cases, state constitutions and the state Supreme Courts that elucidate their meaning, I think oftentimes can be even more informative as we think about the relationship between the state and the individual, in part because of their own manner of handling textualism and originalism and the history of each geographic location and how that relates to the national history. And so it makes for a fascinating, I think, course of study and illuminates ultimately how we think about not only state constitutions, but the US Constitution as well.
This discussion makes me think as someone who focuses on criminal law and criminal procedure, one setting in which the relationship between federal and state constitutional law is especially obvious is when it comes to individual rights in the criminal context. The term that's often used by academics is the new judicial federalism, but in the 70s and 80s, the idea that on contested questions of constitutional criminal procedure, the federal constitution might give one answer, but states might be more protective of individual rights in various settings. And on questions that haven't yet been addressed by the federal courts or by the US Supreme Court, it's often state courts that are the first to confront. Is it a reasonable search and seizure to collect the DNA sample of every felony suspect, or to search an entire cell phone when it comes incident to an arrest? And then those decisions of state Supreme Courts inform the judgment of the US Supreme Court, which finally comes along. So this dialogue, I guess, between federal and state courts on the many subjects where state constitutions and the US Constitution address the same subject. I think it's very much a conversation as opposed to a one-sided command from the United States Supreme Court. Okay, so from a quick history, let's talk about the present and the way that you see state courts interacting with state constitutional law and federal constitutional law issues, and advocates interacting with litigating on behalf of states. I'll start with you this time, General Fisher, partly because I'm curious, you mentioned the different kinds of, as someone who spends a lot of time defending state laws against constitutional challenge, I'm curious how often the challenges you're confronting are purely federal law challenges, purely state law questions, or both of the above, and where you're doing most of your litigating. Just as a descriptive matter, I'm curious if you're most often defending in the state courts or in the federal courts, or it's a mixture of those.
Well, lately it's probably been predominantly federal. I'd say over the last 20 years, which is how long I've been in the office, it's roughly 50-50, and that makes me happy. I really like to litigate state constitutional questions in state courts, and sometimes that means either follow-on litigation or even parallel litigation with a federal claim. In the circumstance, for example, of voter ID, this was 12, 13 years ago now. We went through an entire course of federal litigation all the way up to the US Supreme Court, and our voter ID law was upheld. And just as I was thinking, oh, thank God we won. Next day, lawsuit gets filed in state court over under the state constitution. And I kind of expected it, but maybe hoped a little bit that it wouldn't happen. But there it was. And you know, I embraced the opportunity. I love the opportunity to talk about what the state constitution means on voting rights and to dig into the source of that or those provisions, and to have a chance to kind of do right by the Indiana Constitution and the people of Indiana, to bring to the Indiana Supreme Court eventually a case worth deciding. Now, not every case that we get that raises a state constitutional issue has that same opportunity, and we depend a lot on the lawyers bringing the claims to do a really good job of putting us as the state, you know, through our paces. Because believe me, it's much better, it's much easier actually in some respects as a state's lawyer to get a really good disquisition on the state constitution from a plaintiff's lawyer who's bringing that claim, because then we know kind of what it is we're supposed to be responding to, and we think we have some better idea of what the debate's about. When we don't have that, we still feel the responsibility to dig into all of the minutia that you would expect in an important constitutional question, going back to the debates over the Indiana Constitution, all of the organic documents that we can dig up, all of the sources of original understanding that we can find, because we ultimately want the state Supreme Court to come to the right decision, and one that's well informed. It's always an interesting exercise. I mean, our court is our Indiana Supreme Court is so terrific on these questions about how they handle them, that we're always, you know, we do our best to put together in the space and in the limits we have a brief that gets into all of that original understanding, and then we sort of wait and see, well, we've got some really smart justices. What are they going to come back with that we didn't find about original understanding? There's always something, and that makes the exercise educational and interesting as well. But you know, it ebbs and flows in terms of what we see and the types of laws that the legislature is passing that get attacked, and the place that those aggrieved by those laws think they're going to have the best shot at prevailing. And sometimes that's in the state Supreme Court, especially if there's an analog federal question. It's been pretty clearly decided. But one of the things that pays about having been there so long is I've gotten to see, you know, there's been enough time for people to raise claims that may not in a different area have occurred to them, and gives us a chance to litigate some lesser known state constitutional provisions that maybe don't have analogs in the federal system.
Well, as General Fisher alluded to, there are independent provisions within our own Indiana Constitution. Some have obvious federal counterparts, some do not, particularly in the area that Professor Scott identified, criminal protections for those charged with crimes. We have many counterpart provisions. And of course, the federal Constitution sets the floor, at least early on. This is less true today, largely in many respects due to the author of the Price versus State opinion that General Fisher referenced, former Chief Justice Randy Shepard, who not only as a justice on our court, but as an academic who has studied state constitutions and written really quite broadly on the subject of giving independent meaning to state constitutions. His tenure on our court, which ran from 1985 through 2012, thereabouts, 25 years as Chief Justice, 27 years as a member of our court. He was really not only a first-rate administrator, but a first-rate legal mind, and helped set Indiana on the path of resurrecting, of refinding our roots as a separate source of constitutional rights. What often has happened in our court and on other state Supreme Courts is that there had been this tendency toward lockstep, particularly in the era beginning in the early to mid 20th century, when the Supreme Court of the United States would begin to enforce through selective incorporation this idea that particular provisions of the Federal Bill of Rights would be applied and enforced against states through the Due Process Clause of the 14th Amendment. That trend, which really began to take a strong effect during the Warren Court years and the expansion of federal protection for criminal defendants. In many cases, because the federal courts were where the action was, state courts, all too often, my own included, were content to sit back and see what the federal courts, what the Supreme Court of the United States would say about those rights and simply follow suit, the so-called lockstep effect. If there's a counterpart provision in the state constitution that's in some cases almost identical to its federal counterpart, we and others would simply let that federal standard be the guiding principle for Indiana. For example, Article 1, Section 11 of our state constitution, which is the Fourth Amendment counterpart, the right of the people to be secure in their persons, houses, papers, and effects shall not be violated, etc. We have now strayed away from strict Fourth Amendment jurisprudence. We haven't gone, in my view, nearly as far as we should. One question becomes, even though you have an almost identical provision, is there some reason for thinking that perhaps that provision should not be interpreted in accordance with its federal counterpart? It seems to me there's a strong argument that the answer is yes, it should not be interpreted the same way. The Constitution under which we operate today is the 1851 Constitution, which was, of course, ratified in Indiana long before there was incorporation, long before the Supreme Court of the United States, for good or ill, and it's not my call, has, in the view of some, eroded Fourth Amendment protections. Seems to me that there's a strong case to be made under our state constitution for recognizing the original understanding of that provision. Should be, if we're going to follow the federal model, it should be the federal model as it existed in 1851, devoid of the exceptions that we've seen, especially in the last 25 or 30 years. That's not yet the law of our state. When my colleagues and I go around the state, whether it's to law schools like this, whether it's to bar groups, judicial conferences and the like, we often encourage those who we speak to, whether it's practicing lawyers, raise state constitutional claims, trial judges entertain state constitutional claims. Now, we don't have much choice if the litigants before us raise only federal claims. And I don't want to tread into what may be uncomfortable ground on the Timms case. I don't know if that's right. I don't know.
I'm long past being uncomfortable about that case. It's all right. Just go ahead.
I don't know if we want to go there or not, but that was I'll raise the issue and then retreat from it. But the point simply is we don't have the opportunity to adjudicate state claims if they haven't been raised by the litigants who come before us. And part of that is the litigant's fault, but part of it is our fault. That is the judge's fault. And I'm a counterpart of mine who sits on Arizona's highest court, Justice Clint Bolick, who is a superstar among state appellate judges, and frankly is a superstar among appellate judges generally. He had a terrific career as a practicing lawyer before he went on the bench, and he's only continued his excellence and his forward thinking as a member of Arizona's highest court. But he has a forthcoming article that's going to be published, I believe, later this year, in which he also points the finger at his own court and says, and what he says of his own court is no less true of ours, and that is, we really shouldn't expect litigants to be raising state constitutional claims, which takes a great deal of effort. General Fisher talked about doing research and doing the legwork that it takes. What is the original meaning of a provision of an 1851 Indiana Constitution? If there's no certain return for that investment of time and resources. We, on our state judiciary, state courts generally could do a better job of providing clear, coherent, understandable ways in which, one, we tell those who come before us what we're going to be looking at when it comes to interpreting our state constitutions. Pardon me. And at the same time, perhaps giving those litigants some basis for thinking that what we decide as a matter of state constitutional law isn't just some subjective, ad hoc, results-oriented outcome, that it actually has a coherent, principled theme that undergirds that jurisprudence. And we've done, I think, a fair job in Indiana of beginning to move the ball in that direction. But there are any number of places, it seems to me, in which we have yet to go. We haven't yet. There are plenty of provisions in our state constitution, especially in the area of contract rights, privacy rights, economic rights that really have not gotten much attention at all. And for example, just one area of federal takings law, the regulatory takings case law from, when did Justice Brennan write Penn Central? Was that a 70s era case? I think you could count on the fingers of one hand the number of successful regulatory takings cases that have survived the Penn Central test. I'm not in a position to tell you what the forthcoming Indiana regulatory or confiscatory takings case would look standard would look like, but you wouldn't be any less successful under making those cases under the Indiana Constitution than you have been under the United States Constitution. So my suggestion for litigants, as well as for courts hearing these things, is you bring them to us and we'll try to give you some criteria by which we decide whether those things make sense in a particular case.
Well, if we're talking about why litigants don't raise state constitutional claims frequently enough or well enough, let me share the blame for that. I teach criminal law and criminal procedure, and I focus a lot on federal constitutional law. Events like this and classes like General Fisher's class are a great antidote to that. But I think law schools train us to think about federal constitutional claims a lot more. I think it would be tough to go out into the world fresh from law school and immediately start making effective state constitutional law claims. We just don't have the training for it. So let's try to do better on that front. And on that subject, I thought just to give a little bit more concrete content to differences between constitutional law and federal and state constitutional law, without stealing the thunder from your class in the spring too badly. What are the top 2 or 3 differences, ways in which Indiana's constitution or state constitutions generally differ from federal constitutional law? We've talked about a couple where you see promise for changing down the road. Where are state and federal law already different in terms of substantive constitutional law?
Well, I mean, there's state constitutions tend to have more specific provisions, and so you can find sources that are textual that will depart. One of the most fascinating areas has to do with how state and federal constitutions compare or contrast on the issue of equality. And state constitution, we always look at the federal constitution towards the Equal Protection Clause, and we're familiar with the various kind of gradations of rights and how those are treated. State constitutions sometimes have multiple ways of embracing equality and commanding equality, and they do it through what might appropriately be termed an equal protection analog. In Indiana, we call it the Equal Privileges and Immunities Clause. But it's also done in sometimes preambles. It's done through I think of the Indiana Constitution's local and special laws restriction as a form of equality. You can't have a law that is localized and geared towards a special group. And it comes out of a history of constitutionalism that was meant to rebuff corporatism and special privileges for the elite. And so we think, you can think about many different provisions of the state constitution as a command towards equality. And what state Supreme Courts do with that oftentimes departs very significantly from what the U.S. Supreme Court and federal courts do with the Equal Protection Clause. There are some states where the state Supreme Court has taken an equality command and turned it not into a test for intentionality or facial discrimination, but sometimes into a test for disparate impact. And there's interesting questions as to whether that's justified based on that state's original understanding of that textual provision, or if it's justified by text or some structural feature. But it is certainly an area where I always find it interesting to see where you might, just to kind of oversimplify it a little bit, have the federal court saying those two things are treated differently, but they're not equal, and then a state constitutional interpretation saying, oh, those two things are treated differently, but they are in fact equal. and you would think, well, how can that be the case when it's the same thing? But it has to do with the history and the text and kind of the different understanding of multiple constitutional texts that state Supreme Courts have to grapple with.
And on the subject, for example, of Article 1, Section 23, Indiana's Equal Privileges and Immunities Clause. I think it was for the entirety of our state's history, from the 1851 Constitution through 1994, your General Fisher graduated from that our court in Collins versus Day said, no, forget about tracking, forget about this lockstep approach. We're going to interpret our state counterpart provision differently. And only in the last, not less than 30 years, have we given independent meaning to the Equal Privileges and Immunities Clause. Sometimes it turns out we actually afford greater protection for equality under that provision, sometimes less than the federal counterpart. But since the federal counterpart is the floor, what we have decided to be an enhanced right under our Equal Privileges and Immunities Clause is certainly worthy of raising in connection with a state claim.
You know, one thing I always like to interject in these kinds of conversations that makes Indiana special, and this goes back a little bit to the property rights that Justice Slaughter was mentioning earlier. You may be surprised to know that there is in Indiana a constitutional right to scalp your tickets. It's true. It's true. There is a decision.
The NCAA notwithstanding.
Well, that's right. That's right. We have to see if those things get contested and where these rights stand these days. But the point is, there's a decision out there that embraces the theory that your tickets are your property and you have the right to sell them at whatever price you can get, and a local regulation that tries to stop that is not within the police power of the state. Which isn't to say there aren't decisions in tension with that principle, but it is at least that case is still good law, and it's kind of interesting to think about.
I'll throw out as one more, I think, a common difference between state constitutions and the US Constitution is that many state constitutions and state Supreme Courts treat separation of powers questions very differently at the state level, especially as it concerns the judiciary. So in a federal court, to have standing to bring a claim, you can't just invoke your status as a taxpayer. But a lot of state courts, including Indiana, allow taxpayer plaintiffs in some circumstances to advance claims. Federal courts won't issue advisory opinions, but some state Supreme Courts cheerfully give advisory opinions at the request of the legislature. A different role for the judiciary and some differences between the other branches, the lines of power between other branches at the state level as well. And another sort of core structural difference between state and federal constitutions is the way that they're revised. Amending the US Constitution, notoriously difficult. It takes many years and supermajorities and lots of states to concur. State constitutions can be changed through a simple majority vote. It's usually similar to a ballot initiative, and that means it's, I guess, both easier to reverse a decision about state constitutional law that the voters don't care for. It also it influences the interpretation of the state constitution, I suppose. In stare decisis doctrine, one of the considerations in constitutional claims is how easy it is to revise. So I'm just trying to highlight some high-level differences between state and federal constitutions. Okay, we've got maybe 10 more minutes before we turn to Q&A. So let me ask about the future then. If you're predicting trends in state constitutional law, trends in lawyering around constitutional law issues, what do you see coming in the next decade or so as our political climate has changed, and how do you see things playing out on the state constitutional law front going forward?
Well, this is aspirational. I hope what we see going forward is more is guidance from our court on what we're looking for, what it takes to raise successfully a state constitutional claim. That litigants will take the bait and will accept our invitations to raise state constitutional claims, and that we will give independent meaning to important provisions of our state constitution that don't really have a clean counterpart under the federal constitution, or that provide more substantive rights than the U.S. Supreme Court has seen fit to give under the United States Constitution. And I mentioned before the areas of economics, property rights, and the like. Contracts clause, for example, in the U.S. Constitution is, if not a dead letter, it's virtually a dead letter. It seems to me there's some opportunity for litigation in our courts about the counterpart state provision of our Constitution. I've talked about the takings clause. It seems to me that that could be a fertile area.
Making a mental note. Okay. All right.
in your proprietary capacity?
Well, I think part of what I envisioned for the future in some respects is just a product of what I've fortunately been seeing for the last 20 years, which is not only have we, I think, in government been doing a better job of digging up and all of the important historical details surrounding constitutional texts, but we've seen those on the other side of the V do the same thing. And that's, I think, like I said, that's both rewarding, but also helpful, hopefully, for the development of the rule of law. And as state, I think, constitutionalism becomes resurgent, and I think that is going to continue to be the case, then I guess my hope, it's aspirational to some degree, but it's also backed a little bit by recent years of experience, is that we'll see better and better lawyering on both sides to really get to the important historical texts, the important events that gave rise to constitutional provisions to help get at an original understanding that justifies decisions that ultimately come out of our state Supreme Court. And I think it's one of the exciting projects or enterprises, perhaps, that I've been involved in is trying to take the kinds of kind of originalist, textualist principles that folks in the Federal Society have come to embrace over the years, and kind of that Scalia-esque approach to the law, and try to see how well we can apply it to state constitutional law. And I think it's really very interesting to see that, because we don't have as many preconceived ideas about where courts have gone wrong. We have a pretty good sense, I think, when we look at the US Supreme Court, each of us has a sense of where we think the court went wrong in one way or another, and how maybe originalism or textualism could have, better adherence to it could have yielded a better result. But it's really, for most of us, when we look at state constitutional law, it's a chance to take those principles and apply them to something we don't know as much about, and to see what kinds of results we get. And we may not like the results we get, but the reward there is in taking those principles and applying them to something new, and understanding even better the importance of adhering to things like original understanding and textualism and structuralism.
So I'm going to tread lightly here, because I don't want to put you in an awkward spot, but I do want to ask about one trend that I've written some about, which is that people who are in the position as a state attorney general, state solicitor general, of defending state laws. Historically, the job of that person in that position is to defend all state laws. There's been a lot more political attention on that decision in the last 20 years. And so sometimes state solicitors general will find themselves in the uncomfortable position of defending a law that was maybe passed by the other political party. And it puts you in the, so if you're a Republican attorney general and you're called upon to defend a gun control law against the Second Amendment attack, or if you're a Democratic attorney general and you're called upon to defend an abortion restriction, that's very politically unpopular with the base, and that's a good way to not get reelected. Am I right that this has become, that there's been more attention on these litigation decisions, and do you see this becoming a kind of conflict of interest, or a point of tension, or a pressure for, I'm thinking now about litigants for the state.
Well, now we're getting into the other class that I teach on representing the state, which is great. These are terrific questions, and ones that I have thought a lot about over the last 20 years. And the issues that kind of crystallize with questions about what we call duty to defend have changed over time. But I'm hoping that state AGs are having a better time now, kind of grappling with the principles involved than maybe they did 20 years ago, because the politics do seem to be more pressurized when it comes to making what ought to be, I think, uncontroversial decisions about defending the laws that a state has enacted. So I can just tell you, not every AG will look at it the same way, but I've been fortunate enough to work for bosses in Indiana that have taken duty to defend very seriously. In fact, I worked with one of my former bosses, AG Zeller, on an article published in the Indiana Law Journal on duty to defend and the rule of law. And the principle there that we were advocating was state AGs ought to defend state statutes if there's any good faith basis for doing so, even if state AGs disagree with those laws, even if they're enacted by the other party's majority. Those are laws. State AGs have an important role to play and an important role in focusing and articulating state legal policy. There's a lot of responsibility that comes with that important role, and that responsibility is to take seriously the idea that laws need to be defended. They're not to be cast aside simply because one disagrees with them. Now, those principles may or may not be embraced equally around the country by different AGs. Some AGs have a kind of different approach to it, and you know, that's just the nature of the thing. Some states, many states, the AG is constitutional, and so there's a question of what does that constitutional role envision for the AG in making that decision. In Indiana, we are statutory, and I think I'm not sure that we have statutes that tell us that we are to represent the interests of the state, and so it comes down to a question of how the AG envisions the interests of the state. But I think there's a very important responsibility there to defend the statutes as long as there's a good faith basis for doing that. Otherwise, we get into questions about litigation veto and other sort of more political questions that really ought to be legal questions.
I'm going to take off my judicial hat for a moment. General Fisher is 20 years with his 4th Republican Attorney General. I spent 6 years in the Attorney General's office from 95 to 2001 with 3 Democratic Attorneys General. And I can tell you that at least the view of the office then, admittedly, that's been now more than 20 years ago. But General Pam Carter, for whom I worked, she was the first Attorney General whom I served. It was on her, she was a very pro-choice Democratic Attorney General, believed strongly in Roe and women's right to choose. But when our legislature enacted abortion restrictions, what were at the time some of the most restrictive around, 18-hour waiting periods and in-person notification requirements, she said the duty to defend must prevail. And my charge from her to, in fact, it was then Judge David Hamilton of the United States District Court for the Southern District of Indiana who heard these cases. Her view was we need to defend the statute. That's our institutional role, and do the best you can. Now, for good or ill, my efforts to defend the statute failed on my watch, but on appeal, when Fisher took over under a Republican Attorney General, the state's position was vindicated in the 7th Circuit. I'll let others decide whether that's a good thing or a bad thing, but both attorneys general of both parties believed it important to defend the legislation, whether or not they believed in their own personal views and whether it was the right thing or not.
Excellent. We've got about 15 minutes left, and I think this would be a good time to turn to the audience. I've got one hand already.
Just a quick comment and then a question. Tom, I don't know if you teach this in your class. There's a really interesting illustration, I think, of this in the same-sex marriage fight in this country. 10 years before the first federal case was filed, organizations were filing these cases in state courts. They would pick out states where they thought the constitutions or the interpretations of the equality provisions were especially favorable. And the idea was to get favorable rulings in places like Massachusetts and Iowa, Connecticut, and sort of build a momentum there. So just an example of the strategic use of the differences between the state and federal constitutions. My question is not so much about differences between state and federal, but whether are you aware of any states where local governments and political subdivisions have any sort of protection? Here's what I mean. So, mask mandates or vaccination mandates, city wants to do it, school board wants to do it, governor says no, they can't. I know generally the home rule powers of local governments are just sort of statutory. The state creates the local government, and the local government can only do what the state says. Do those ever involve state constitutional issues that you're aware of? Do local governments and political subdivisions ever have any recourse to state constitutions against the government of the state itself?
Well, I have not seen one of quite that nature where it's a policy like that. There are state constitutional provisions, though, that localities will enforce against state officials if, say, they want to, annex surrounding areas, and they are rebuffed by the state legislature from doing so. That, as you may have inferred, is exactly what happened in the case involving the city of Bloomington last year. And so there are, I think, if there are not provisions that protect cities and towns organically, they at least afford some kind of procedural type protection, or in this case, it was a local and special laws type of protection. Again, sort of the equality. Bloomington was being treated certainly unequally compared to other cities and towns. So there are ways for them to get into court often, even if it's not a direct protection to them as such. And I will add, by the way, yes, we were one of those states too, but it didn't work out quite the same way here as it did in Massachusetts and Iowa.
All right, this is kind of a complicated one, so I hope you bear with me. But I have a couple questions that sort of tie what was said earlier as one of the principles of the Federalist Society, that the judiciary should interpret the law but not say what it should be, with the topic of how the original state constitutions actually influence the creation of the federal constitution. So, as you said, we've had several states who were in existence with their own constitutions and influenced by John Adams' thoughts on government before they drafted the federal constitution. So obviously there was influence there. And yet, as was brought up earlier, a lot of the state constitutions today are very different from what they have been in the past, because there's more ease, it's more malleable, you can adopt them with social change through like referendums or other processes, whereas the federal constitution has been a lot more static comparatively. Obviously some very significant updates, but relative to state constitution, rather static. So with that in mind, would you go so far as to say that the drafters of the US Constitution erred in making its amendment process so obtuse compared to state constitutions it was influenced by? And if so, do you think the obtuseness of that amendment process is what has led in recent years to what they call legislating from the bench? Just because it's so difficult to make a constitutional change with the normal method, that justices have been forced to update the Constitution through interpretation.
Jeff, you want to take that on?
Sure. I'm not sure I would say that the framers of the US Constitution erred by making the amendment process so rigorous, so difficult. I think the last amendment to the United States Constitution was 92, an oddball provision that was originally supposed to be part of the Bill of Rights that said one Congress cannot raise its own salary, any salary increases can't take effect until the next Congress. Okay, what we do? I mean, it's an amendment. Last time the Indiana Constitution amended, I think, was in 2018 to provide an amendment dealing with circumstances in which the legislature could deviate from a balanced budget. You're right, obviously, to point out that the Indiana Constitution is much more easily amendable, and it's happened much more often in recent years. Personally, this is a value judgment. It's not a legal judgment. I think it's a good thing that the U.S. Constitution is not so easily amended. I wouldn't want the First Amendment protections, for example, to be done away with by a relatively arbitrary temporary majority. What does that mean for the value of the Indiana constitutional rights? I mean, the trend, at least under our own recent history in Indiana, is that the amendment process has yielded greater protections of individual freedoms, even though it's been amended more frequently. Now, could the opposite happen? Sure, it hasn't, and maybe that trend will begin to reverse itself, but in recent history, that hasn't changed. As a consequence, because the federal constitution is so much more difficult to amend, there are those who have a different judicial philosophy in mind, who think it's valuable to turn to the federal courts to achieve results that I think most of us, a wide consensus of us, would find to be a desirable result. I applaud the results. I don't always applaud the means by which we got there, but that's what the process is all about.
I guess the only thing I would add is that I even if the U.S. Constitution were easier to amend, my sense is that we would still see, judges legislating from the bench. It's one of those, those who do it never admit that that's what they're doing. It tends to be part of their overall judicial philosophy, which I wouldn't expect would change even with an easier amendment process.
With the recent change in judges being more amenable to a parallel claim under state constitution versus federal constitution, specifically in the realm of criminal defense, does it raise the minimum acceptable bar for defense lawyers? It's almost pro se ineffective assistance if they don't raise claims under both constitutions now?
Why don't you take that?
Well, I think there are bound to be specific scenarios where that may be the case, but I don't think in general, every criminal defendant is always going to have a more, I guess, aggressive strategy available under a state constitution. But sometimes that may well be true. And certainly the criminal defense bar needs to be aware of opportunities as well as, existing doctrines. And it's always interesting and exciting to see when the criminal defense bar comes up with a new strategy, a new thought about how the state constitution might yield a different result in the federal constitution. Those don't always work out, but I certainly applaud the efforts. But every case is going to be different, and it's sometimes going to be better and sometimes not better.
Well, I can't, oh, go ahead, please.
Well, I was going to say, as to ineffective assistance, I think that would rarely be the case unless and until there's a very clear state constitutional right that the lawyer failed to raise. It would probably be within the broad discretion of counsel to not raise a claim, that to try to generate a new heretofore unrecognized state constitutional law claim. That's just sort of the constitutional minimum for effective lawyering, but I don't think that would be common. That said, I think it would behoove defense bars and public defenders' offices to think carefully and strategically about where there might be profitable areas to generate new constitutional law under the state constitution that doesn't yet exist.
We have time for one more question. I think I'll defer. Go ahead. There's one behind you.
So mine kind of has to do with thinking about litigating under state constitutions when the texts are pretty much similar or exactly identical to the Supreme Court. So if you have a situation where perhaps it's maybe an issue of first impression under the state constitution, but it seems to be a question that's already been answered by the Supreme Court. If you're trying to, I guess, deviate from the Supreme Court's jurisprudence, what kind of source material are you going to be relying on to produce a different outcome under a state constitution when the text is identical or similar?
Go ahead.
I think that's an excellent question, and it seems to me that perhaps the obvious, at least the initial reflexive response is, well, if the state counterpart is verbatim, it's the federal provision, why wouldn't it be interpreted the same way? And those who are trying to make the case that it should be interpreted in a different way, it seems to me, are not without some resources. As I alluded to in some earlier remarks about our own Indiana Constitution, Article 1, Section 11 of our state constitution is the Fourth Amendment counterpart under Indiana law. It was ratified in 1851. And although it reads almost verbatim the federal provision, it seems to me at a minimum what somebody who's making the case for an independent reading under our state constitution could say would be, well, what the framers of the Indiana Constitution were doing in 1851 was adopting as the law of Indiana, the organic law of Indiana, the Fourth Amendment jurisprudence as it existed at that time, as interpreted by the Supreme Court of the United States. And whatever may have happened in the intervening 170 years may be interesting by the Supreme Court of the United States, but that's not relevant to what the framers of the 1851 Constitution of Indiana did. So come back to us, for example, and tell us, one, is the presumption correct that what the framers of the Indiana Constitution were doing in 1851 was embracing the federal standard? And beyond that, tell me what was the prevailing law from the Supreme Court of the United States in 1851? What exceptions to the Fourth Amendment existed? What provisions, what exceptions and so on did not exist that have only come to pass in relatively recent years, and make the case based on that record that despite the identical language or near identical language, there's to be independent meaning to be given to the state counterpart. We've not seen that, but it seems to me that's a ripe area for some research and advocacy.
I think another strategy there is to try to, as an advocate, and I suppose as a judge maybe, but one if you want to give life to independent life to the state constitutional provision, is to resist the temptation to think about it in relation to the federal constitution. In other words, is this a case about departing from the federal standard, or is this a case about understanding the state standard? And try to frame it independently to begin with. And then where does that lead you? What questions does that lead you to ask and answer about the sources? And when you look at it that way, maybe whatever doctrinal resources were available at the time become just part of the mix, and they don't tend to necessarily drive the debate quite as much. And so you can have a re-examination of common sources, and you can have an examination of doctrinal sources, and then add to that an examination of local or state, just sort of more state-focused sources of what was being discussed. And you can come to, hopefully, what will end up being, whatever the answer, something that is genuinely independent of the federal answer.
One more option, I suppose, when the state analog is similar to, but not identical to, seize on those differences. Does it say cruel and unusual punishment versus cruel or unusual punishment? That might be an indication that the drafters of the state constitution meant for something different. They didn't use the exact same words. That might have been intentional. Well, thanks very much. Thanks to our panelists. It's been a pleasure. Good to see you.
So if I asked a question,
Yes.
it was going to be about, I'm always interested in the federalism aspects of the state providing more protection. I'm specifically thinking about criminal procedure.
Yeah.
When a state does provide more protection, it creates that gap in which federal actors can get caught in the gap where they're complying with federal law, but not with the higher state protection. And it's the opposite of the old silver platter doctrine problem. But of course, back in those days, when the federal law didn't apply to the state actors anyway, the only question was could they hand it off to the feds? Now it's kind of a different problem because you have the reverse silver platter issue of collaboration to avoid the state's higher standard. But you also have the fact that the federal actor might, in some situations, claim that under supremacy, they can pursue the federal interest regardless of the state's higher standard.
Right. Oh, I could well imagine, yeah.
I think that's just a fascinating sort of backwater conflict of federalism that doesn't get a lot of attention, but could. I mean, it's a really interesting legal question of whether federal actors and under what circumstances can they be restricted in the pursuit of federal policy by a state's higher.
Especially when it's been handed off by a state actor violating the state standard.
Well, that would be that's the reverse silver platter issue.
Right.
But there was actually a conflict. This actually popped up into reality when some states started to discipline. There were cases in which federal prosecutors would, under certain circumstances, try to deal directly with a defendant on a plea bargain or something. And this, of course, and then there were states that said, no, that's a violation under our law. And the feds were like, well, but wait a minute, we're doing something in pursuance of federal policy here. And then the states tried to disbar those prosecutors from doing it.
What result?
I think it was, I don't think there ever was a sort of conclusive, it's going to come out one way or the other. It's the kind of thing that probably doesn't get a lot of, air. I mean, there's probably not a lot of cases where, but you can certainly see how the problem would arise. An FBI agent investigating terrorism or something, and then suddenly runs afoul of a state's version of the Fourth Amendment that's more protective than the federal version. I don't know what happens in that situation.
It's hard to imagine that the state standard would bar the federal prosecution in that circumstance because of the state standard. I would think preemption.
But does the state constitution even give protection against federal officials?
That's the question. If they're operating within the state,
I've not seen that that's the case in Indiana.
And if they're operating within the state and they're doing it, let's say, to a resident of the state, does that have any meaning there?
If there's a prosecution in federal court, would a federal court exclude evidence based on a violation of the
this is kind of, I think it's a backwater area that has gotten relatively.
Well, I know they
little
don't
attention.
exclude evidence when we assert deliberate process privilege, so there are certainly limits vis-a-vis the government that way.
Anyway, that was my question, so.
But that's great.
Yeah, this is great.
See you guys again soon.
Yeah,
How's your son?
yeah, sure.
How is your? Oh, I haven't seen your
So
son.
I have reservations at Uptown Cafe
Oh, nice.
at 1:30. If you
Terrific.
would like to join us, Professor Scott, we've got 7. There's spots for 7. But yeah.
He's having, he's, you know, he's still with,
That was
you know, now
fantastic.
that firm is part of. this
Huh?
That was
massive
fantastic.
event.
Oh, I'm glad you liked it. Yeah, that was a lot of fun. Yeah, that was fun.
Which has brought them a
Great way to
lot of
start.
interesting work. You know, what's happened with that is that basically Denton, this is part of their business plan. They use an office.
Good to see you. Yeah.
Sounds like a while.
Yeah, good event. That's nice. I did a good job of pulling it together. So,
New
yeah.
York.
Thanks for coming down.
Yeah, see.
But it looks like they had the camera going. Sounds like you've got a couple of questions at the
They sent.
Yeah.
The audience? Yeah, thank you so much.
Oh, yeah,
Really.
really.
Why did you-
Yeah.
Yeah, somebody was saying.
Yeah.
Definitely. Yeah.
What I did, I
Uh,
continued to-
Can,
Yeah.
I think it's Shan Mugan.
Uh-huh.
I asked him to come do a Supreme Court roundup here and because he's going to the Indianapolis lawyer. Yes. And he's like, oh, I'm just waiting for that. I got a Supreme Court brief to do the next day. And I was like, he's like, tell Tom I said hi. I was like,
Yeah.
"Okay."
I'll see him. He'll be, I just got the invite. Yeah, so I'll see him. In fact, I've had to, he comes every year to Indy, and
Oh, he does?
but I've had to miss the last couple, so it'll be good to see him.
Did you
Yeah.
have pretty well?
This was great.
Oh, you know,
Just
well
around,
enough. Yeah, no, we certainly, we've interacted mostly just in FedSoc kind of stuff, but we've been on a couple cases. So. Terrific.
Is he? Yeah.
Just amazing guy.
So who else came to lunch? Are you coming to lunch?
No, I got class. This is my board. So you guys
Yeah.
introduce
Oh,
me.
hi.
I'm Michael, I'm the vice president.
Oh,
Nice to meet you.
Nice to meet you.
Nicholas Bruce Power Events.
Oh,
Pleasure to meet you.
yeah, nice to meet you.
Hi.
Pleasure to meet you.
Well, thank you so much for coming in. That was great. That
Oh, that's good.
was all we can ever ask for.
Oh, no, that's my pleasure. I'm always honored to be asked. I love this kind of stuff. so.
Interesting time. Especially for like Constitution Day.
That was the first time I heard about the ticket scalping being,
Yeah.
there's case law to back that up. That's gonna be fun.
Isn't that fun?
Yeah, I'm gonna regurgitate that to everyone I
That's
know.
right.
My new favorite tailgate.
So it's a great scenario. It's a great instance though, where we sit here and we look at it, federal society types, we tend to be fairly, pro-property rights. We think, well, it's kind of an exciting thing, especially if you like sports and you like, that environment. But then you think about how we got there. And is it because there's a text in the Indiana Constitution that says tickets, scalping is a constitutional right? No, it's because the Indiana courts in that era applied what we would characterize as a Lochner doctrine, where it was any police power usage that was meant to curtail the right of contract was suspect. And so there's a whole line of cases that preceded that are things that we would typically think of today, like, my God, how can that possibly be off limits? In fact, there was also one where the Indiana Supreme Court invalidated restrictions on beer sales. And so there was a right for a time under the Indiana Constitution to make and transport and sell beer. And then, I don't know, 25 years later, the Indiana Supreme Court got a hold of that issue again and looked at that prior case and said, yeah, we said this in this prior case. We can't be sure what source of constitutional law the court was thinking of then. And so now we're going to go do something else. And so it's one of those great things where you look at it and think, on the one hand, boy, that's kind of a neat outcome. And then you look at the way they got there, and you think, oh.
So you said Lochner style jurisprudence was that same era?
Oh, yeah. Oh, yeah.
Wonderful. All right, this is Michael. He's our vice
Thank you,
president.
Justice Slaughter. That was great.
Thanks for
I'm
coming.
not gonna be able to make it to lunch, but thank you so much for coming in. That was
I
awesome.
hope you got some Chick-fil-A.
Oh, I got plenty.
Okay.
Is the plan to walk down?
Yeah.
So that, okay. Do you mind if I join you 10 minutes later? I'm gonna run up and do something in my office quick.
Yeah, of course, of
I
course.
Yeah, we'll see you there.
didn't know there was a lunch plan, but I can actually go this time.
That's
So I'll
great.
join you.
All right, nice to meet you guys. Thank you so much.
All right.
Good to see you.
Going to lunch?
Yes.
Oh, good.
Do we have a place picked out, or we just?
Like you said, Michael's Uptown Cafe is where we're
Oh,
going.
that's a wonderful spot.
Okay, are we watching? I think we're watching this. Yeah, I think we're watching. We go over everything. I'm not sure. Did you get require so?
We have a couple more.